Every rule might have some exceptions, but I think the answer is the public is allowed in, which means the media are allowed in, except, and there's a case called Bone Club that allowed extraordinary situation where a judge makes findings of any. I talked to Judge Lasnik, who did the Hells Angels murder cases up in Seattle, and that's, of course, that's federal. But they made a specific finding because these Hells Angels were intimidating to the witnesses, et cetera, and so he kept people out. But these are, I don't think I've ever seen one in this state. So there is an exception for the judiciary. The general rule is our courtrooms are open to the public, and the media serve as the vehicle to make that real. And as you were in our court, I love telling the story, and I probably did to you. You look up and there are 2 cameras there. And I love the fact, I mean, we were one of the first courts to do that. Why? Because it's open public proceedings. I used to love to tell the kids the story, by the way. My mom is always watching, so this is not a bad rule for all kids. My mom died 2 months ago, but it's not a bad rule, but more the point of the story, of course, is the public is watching. And that, I repeat for the 3rd time, that's the sanitizing effect. We have chosen that as a way to make sure the justice system is full and fair.
I think the records that are available is often the issue, not the actual physical access.
We're rolling back since I've been on the court, we've rolled back sealing, the so-called sealing of records a lot. But these cases do come to us, but I think you'll find the thrust of the court is against it.
I actually have a lot of agreement with what Justice Johnson says. I believe that the courtroom should be open in virtually all proceedings. The Bone Club findings are designed specifically to set the bar extremely high when there's a danger to victims who may be re-victimized by individuals who seek to intimidate witnesses or other very extreme circumstances. But the general trend in the state of Washington, for not just in the courts, but for all public records, is that they're public, that files shouldn't be sealed. In 1972, we passed the Public Records Act by initiative because the people demanded open records. The statutes require that public meetings be open. I think that you know, there's a reason for that. The citizens of Washington want transparency in their government, and that includes the judiciary. I believe that really the bench bar press guidelines that have been worked out over the years still need some tweaking. I think that in cases where there is general public interest, a fixed camera in the courtroom, just as they have in the Supreme Court, isn't a bad idea. You know, you don't want to disrupt the proceedings or be intrusive, but I think that the people have a right to know what's going on in the court, and just because you can't get down there to get into the courtroom yourself doesn't mean that, that the press or the print media or the electronic media or whatever it happens to be shouldn't have reasonable access really at all phases of the proceeding, unless there's a specific identifiable reason that most rational people could look at and say, okay. You know,
as an educational vehicle for the kids and the citizens to see what's going on in the justice system. It's far better than this Judge Judy and all this crap that we see on TV that is not an accurate depiction of how
you just lost a lot of votes right there.
Oh,
better
sorry.
be careful what you say.
I happen to think we're in the real world, right? We try cases in the real world. It isn't bad to have
Judge Judy, I'll tell you that.
Well, I want to, we've gone a little bit over an hour, and I promise you to try to keep it to an hour, and I know you have a little more to your trip
Down to
today
Walla
to go
Walla.
head down to Walla Walla. So we'll go ahead and move to closing, and as I said at the beginning, we'll go in the same order. So, Mr. Roomba, you have 2 minutes to start.
Well, thank you very much. And, you know, one of the things that I believe is important when the voters go to the polls and look at this race, Position 1 in the state Supreme Court, which is August 17th, the race will be decided in the primary, is to review the material, review the background of each of the candidates, and make a selection. I have represented lots of people who, for example, have been overreached by large corporations, banks, insurance companies, have been subjected to sharp practices, and I've brought cases under the Insurance Fair Conduct Act and the Washington State Consumer Protection Act. My opponent in cases has sought to curtail the access of Washington citizens to consumer protection remedies. Just recently in the McCurry versus Chevy Chase Bank case, trying to import more restrictive federal regulations that provide greater protections for insurance companies. The majority in that case pointed back to our state consumer protection laws and said, no, we are going to give our consumers remedies in the courts for the overreaching of these practices. The singular wire, Scott versus singular wireless case is another example of my opponent imposing federal regulations that restrict the right of Washington citizens to access the courts for consumer remedies. The courts are about the people. They are there to serve the people. Everybody that goes to court is entitled to look up and see a judicial officer that is fair-minded and whose sole goal is to apply the laws that is written with the intent of the law that the legislature provided and apply it to the facts, come out with the best decision you can. You're entitled to a fair trial, not a perfect trial. And I will be that person. If you send me to the Supreme Court on August 17th, I will serve the people as I have in my practice over the last 30 years.
Thank you very much, Mr. Rumbaugh.
Well, a court closing is like the opening. I started here. I came to these counties 6 years ago when I promised that I would protect your constitutional rights and not legislate from the bench. Both counties voted to send me to the Supreme Court. And I'm maybe sometimes of a few who are on your ballot who have done exactly what he promised. And that's why I'm asking for you to vote to send me, to keep me on your Washington Supreme Court to protect your rights. I've been a lifelong Washingtonian, with the exception of the time I spent at Harvard and the U.S. Army. And a digression, when the former chief retires, I'll be the only one on the court who still has experience serving his country in the Army. I spent 2 years doing so. Been married 41 years, and I got 2 kids, one of whom is a school teacher now. Oh no, just promoted to a principal in Seattle. So, and I've long-standing and continuing roots in my community and in my state. So I promise, as I did 6 years ago, if you send me back to the Supreme Court, I'll continue to protect your constitutional rights. Thanks for paying attention.
I want to thank you both for taking the time.
Yeah.
You did beat the buzzer. I want to thank you. Thank you both for coming down and spending your afternoon with us.
Thanks for spending the time.
And I want to thank you both for your willingness to run and serve our state.